Good morning to all participants for the Rouse webinar on how to handle and protect IP in China. My name is Thomas Randis and I am the country manager of Rouse. And before pursuing with this introduction, I would like to make reference to another legal framework, and that is Murphy's Law, which implies that anything that can go wrong will go wrong. And this is what happened in our attempted seminar last Tuesday. And I have to apologize to all participants who wanted to attend the seminar at that time and couldn't. So welcome again and thank you for taking your valuable time again. So what's going to happen the next hour? Right now we are holding the introduction and setting the arena for IP and enforcement in China. At 8:35 until approximately 9:10, our colleagues Tim and Carol will have the larger part of the presentation, and of course we invite everybody to pose their questions for us to respond to. So we will have a separate Q&A session at the end of the webinar, implying that we ask you to write your questions in the function that exists on Teams. You will see the logo and what button to press highlighted in the circle on the screen in front of you. We will collect the questions and pose the questions to the speakers. The webinar will end at 9:30 Central European Time sharp. Do not worry about copying the slides. All the participants will receive the presentation in your email. About Rouse. Rouse is a leading firm within IP. We supply IP services primarily focused on emerging markets. We are on our 30th year of existence and exist in 13 countries in 18 offices. Our exact number of people is actually 657, as I was informed of yesterday. This number may My apologies for the slide issue. Now I think I got the hang of it. Rouse is an IP service firm focused on the emerging markets. We specialize in the most challenging business environments in the world, including 5 offices in China, also including Hong Kong in that number. Due to regulatory reasons, we operate under an additional name for our legal services in China, Lu Sheng, for our legal services. Lu Sheng is our Rouse law firm, which was founded by Rouse and works exclusively for Rouse, and whose partners are all also partners in Rouse. I don't know if you heard this, but I'll repeat it again. Rouse is going on its 30th anniversary this year, and is also present in 13 countries, or 12 countries besides China, with 18 offices, with 657 people who were employed yesterday. At this point, I would also like to advertise webinars for the coming spring. Due to the corona situation, we have moved all our live seminars in the Stockholm office to the web. And here on the site, you see the topics for the seminar. Today is March the 26th, where we hold the Enforcement China seminar. The next month in April, we will have 2 seminars talking about trade secrets, collaboration and control, and on April the 28th on technical innovation and value. On the 28th, we will also have a collaboration with the startup scene companion on the topic on how to protect your idea. We do not then only talk about patenting ideas, but we talk about innovation law in general and how it can be used to protect ideas. In May, we will focus on open source and intellectual property, the duality of open source, the way it is supposed to be open for everybody, but at the same time that it implies strict control, and how to collaborate control and openness, but also on how to implement the legal strategy in agile developing companies. In May, we will talk about the value of IP. This is very much a seminar directed to people with an economic background on valuation of IP. And in June, we will talk about data assets as a leverage in your business. Everybody knows that data is an asset, but very few people today actually create value of it. This was just to advertise our coming webinars, so I hope that you will find some of them interesting and you will be willing to attend or spread the word. Bear in mind that we will also improve with our technical quality during this time. Today's speakers are Tim Smith, who is a principal at Rouse, works for the Rouse consultancy and based in London. And we have Carol Wang, who is a principal at the Lu Sheng law firm and Rouse, and who is based in our office in Shanghai. Making the introduction is myself, Thomas Randus. I'm the country manager and principal in Sweden, and I am assisted by Olle Bratt, who is the assistant manager marketing and sales director in Sweden. And he is the individual who has done the heavy weightlifting for our digital seminars. Going into the topic, what is the Swedish government's approach on China? Last September 2019, the Swedish government posted a approach on the government's position on China, which implies increased collaboration and cooperation on all ends of society. This is nothing strange to the Swedish-Chinese relations, as Sweden was one of the first Western countries to establish diplomatic relations with China in 1950. So the collaboration has existed between the governments for a long time and also within corporations. Swedish companies today have production in China worth about 300 billion SEK. And often these stats are reduced to what is imported and exported, but today Swedish firms need the domestic market of China only to continue developing and competing on the market. For many of these companies, their presence in China is therefore of central importance for any research and development and sales, and necessary for competing on a global dynamic market. At the same time, there is criticism, both in Sweden and in the European Union, that foreign and companies and Chinese companies have not been given the equal opportunities to operate. Do Chinese companies have unfair advantages in comparison to Swedish or European companies? Does the Chinese legal system permit theft, especially in terms of IP? These are questions that we often hear. Are these stereotypes, or is there any truth in this? By stating those questions, I hand over the answers, or the potential answers, to Tim and Carol, please.
Thank you very much, Thomas. Thank you for that introduction. Allow me first of all just to share my slides. Hopefully you can now see a picture of me. So first of all, a brief introduction to me. My name is Tim Smith. As Thomas said, I'm a principal with Rouse Consultancy. This is now my 12th year with Rouse. I started life as an intellectual property litigator with a law firm in London, a large corporate commercial firm, handling quite a lot of litigation as well as some commercial deals. After 8 years there, I moved into an in-house position in the music industry, in the recording industry, where I worked on international litigation for about 5 years. I then joined Rouse in the very end of 2008, and after a short time in London, I transferred to China and lived and worked in Beijing for almost 6 years, running the Rouse office there. It's there that I really began to learn about China, and as is so often the case when you spend time in China, the longer you spend there, the more you realize how little you know. But hopefully I have a little to share today that can help us to understand how the picture is developing. I'm now returned from China to London. I returned about 4 years ago. And my work still largely is focused on China, helping clients understand strategically how they should approach China, whether from a risk point of view, looking at enforcement, or from an opportunity point of view, looking to develop the market. Today, we're going to be looking at the risk side of things. After a brief introduction, I will be looking a little more broadly at the what we call the enforcement toolbox, those tools that are there available to businesses to protect their IP rights and how to strategically plan with those. And then the real focus of this webinar today is around civil litigation and the opportunities that civil litigation gives for businesses, foreign businesses in China these days. For parts 4 and 5, I'm going to be handing over to Carol, and she will take us through some developments in law and practice, particularly regarding brand, and then going to be looking at some case studies, again, particularly focused on branded and retail goods. The presentation will then come back to me to give just a few predictions for 2020. So let me then move into this first part and give a broad view of of the landscape. As Thomas has said, there are many myths that abound regarding China, and on the left-hand side there, you'll see myths and words that I hear often spoken. Some of them less often these days, but many of them still heard. I won't read all of them out, but many of them will probably be familiar to you. Many of them may be views that you hold yourself today. And some of these, I think it's fair to say that some of these were never true. Some of these were true, but I think what we hope to show to you today is that where some of these were challenges, what we are really seeing today is very much a maturing picture. That's the essence of the message that I want to pass on today, is there's been a real maturing in the system for managing civil disputes in China. Following WTO accession in 2001, I think much of the focus in the first decade after that was on the substantive rights. But in the last 10 years, and the last 5 years in particular, what we've really seen is a major focus on increasing the sophistication of the civil dispute mechanisms in China. And there on the right, I show you what I see as the reality today. We have an international standard system supported broadly through government, with government initiatives on education and incentives to invest in IP. We see that foreigners genuinely, in most cases, operate on a level playing field. We've got some data to support that. Corruption is genuinely very rare. We see in those areas particular to civil litigation, we see developments which are very positive. We see a shift away from this great burden on the plaintiff producing evidence, and the burden being shifted in many other situations. We see statutory damages now 10 times what they were. We see courts with multiple mechanisms to enforce payments. And we see that the threat of litigation and what it now represents really means low recidivism and more settlement conversations. This is a positive picture, and this is the message I'd like to bring. So where does litigation fit in the enforcement toolbox? Before we look at that toolbox, I just wanted to bring up this framework. The challenge often in China is where to invest your resources when it comes to enforcement. Still, it is unfortunately the case that there is quite a lot of, there's still counterfeits in the market, there's still copycats, lookalikes, imitations, increasingly imitative innovation, small iterations. There is still quite a lot of that going on in the Chinese market. And therefore, the challenge often is where to invest your resources, which targets to prioritize, and what action to take against those targets, how to deliver the value, the greatest value for the investment you're going to make in that enforcement. This is a framework on the screen now, is a framework we use to help, amongst other things, with the setting of ambitions for a legal team and the planning of activities. So the first step starts in the top left, where we examine in concert with the business the commercial objectives they have, the barriers that exist relating to those commercial objectives that are preventing them achieving them, and therefore the ambitions that the IP team has to try and support the business achieving those commercial objectives. Those ambitions could be, in an enforcement context, it could be reducing interference from lookalikes, or it could be increasing consumer confidence in the quality of the product. Whatever we're trying to do, we're trying to support the business in selling as many products as it can at the highest price point possible. But then as we move from discussing with the business in the commercial perspective down through the planning phase, we see that this is where we need to consider the enforcement toolbox. What do we have in our hand to tackle these issues, and how can they try and help us achieve the impact we want to deliver the value back to the business? So here is a perspective on what we might call the enforcement toolbox. We've set out here a number of tools that are available. Many of these will be familiar to you. Many of these are familiar to you and available in other markets as well. And the way we've mapped them here is to show their cost against what we view as their deterrence. And one of the real skills in China is understanding the strengths and weaknesses of each of these tools and how they can achieve the result against a given target with a given infringement, even in a given jurisdiction with a given commercial ambition of the business. Each of them have different qualities, each of them have different benefits. I'm not going to focus on this on any of these in any great detail except for civil litigation, but I will say a little bit more also about administrative enforcement. I recognise that for some SMEs and even some multinationals as well, litigation can feel like too much of a commitment. I mean, the reality these days in China is that litigation can predictably be run for tens of thousands of dollars, not hundreds of thousands of dollars. But still, that may be an investment that is too much for some businesses. And so administrative enforcement remains a very effective tool in many situations. It's been the mainstay of enforcement in China over the last 20 or so years. It is certainly affordable, costing thousands of dollars, not tens of thousands of dollars, and it can certainly be effective in taking product off the market and therefore causing disruption to infringers. There are concerns that it can be of limited deterrence, where sophisticated infringers are able to reduce the amount of stock that can be seized and therefore see administrative enforcement simply as a cost of doing business. There have also been some challenges just recently in the last year or so where administrative enforcement has been a little less effective. We've had a significant organizational restructure within the administrative enforcement agencies in China, meaning that officers who were previously handling copyright cases might now be handling patent cases or trademark cases. What that has led to is a slightly more conservative view and less willing to take more marginal cases. There's also been a reluctance to take action against the distributors of products, preferring to focus the actions on manufacturers themselves. And there is still, in the context of administrative enforcement, some experience of local protectionism, where enforcement authorities choose not to enforce heavily or at all against large local employers. So it still remains a valuable tool, and absolutely it's a tool that we use in the toolbox all the time. But today what I really want to focus on, as I say, is civil litigation. So I'm going to look at the court structure, the developments in the system, and understand what you can expect. In the last decade, and certainly since 2014, we've seen a major investment in the civil court structures, investment in training, and major resources to improve all aspects of the system. And what this has led to is many bright young judges wanting to be IP judges, and it being seen as a path, a quite respectable path. A lot of the development builds on the creation of the dedicated IP courts in Beijing, Shanghai, and Guangzhou in 2014. That was a major step forward, and it really brought was the beginning of the process that led up to today, with the formation of last year of the new appellate IP court in the Supreme People's Court, of a really coherent set of IP courts, which are really driving consistency and driving guidance across the country as to how IP cases should be handled. So what do these developments mean in terms of what's happened in the last 10 years? I think this graph shows it all. And it shows an extraordinary growth in IP litigation in China. We have had over a 10-fold increase in 10 years. That has been a particular growth in copyright cases, where there's more than 20 times the cases than there were 10 years ago. But still, it's about 9 times in trademark cases and 5 times in patent cases. So by any measure, this is extraordinary growth. And a key thing to mention and key thing to realize is that the vast majority of this litigation is Chinese businesses fighting Chinese businesses over their own markets and their own rights and their own territories, which really demonstrates the growth in understanding and appreciation and value of those assets in the market. This growth continues, and two factors I wanted to highlight that are driving access and efficiency and scale in this system are digitization and the developing evidence procedures. So now we are seeing a real drive, as I say, for the IP industry as a whole and the courts as part of that to become more and more digital. We have online case filing available now in all IP courts and in the IP chambers in the major tribunals outside of the Beijing, Shanghai, and Guangzhou. And increasingly, we're going to see online hearings and evidence exchange. And the coronavirus, I think, is only going to accelerate that. So I think we'll see more and more experimentation in the first half of this year. And also with publishing, many more judgments are now published online. It is a civil law system, so there's not a common law system with precedent. So not all judgments are published, but there's been very strong guidance from the Supreme People's Court to have all of their judgments published. And I'll be coming back to that a little bit later to show some of the data that comes out of that. And as I mentioned, it's not just the court system. We're seeing all aspects of the IP system in China becoming digitized to increase access, to increase efficiency, and to increase speed. And the other aspect that I mentioned was the development in the approaches to evidence. This has been a major gripe for foreign businesses as they have tried and fought litigation in China in the last decade. And we have seen some really positive developments in recent years, and here now evidence rules to be implemented later this year. So we're seeing moves, there's a number of moves here which are going to create positive impact. We see compulsory evidence disclosure for things like financial books to assist plaintiffs in demonstrating the profit that an infringer has made. We see more specific and powerful legal consequences for fake evidence. Historically, there was actually little impact on a defendant if they put in fake evidence. Now we're seeing more serious legal consequences for that. We're seeing more flexibility in the evidence in the submission of evidence, and we're seeing less rigidity in the formality requirements. And we're seeing a rapidly developing guidance and clear guidance around the use of digital evidence. So we think that this is going to reduce the burden on IP owners in particular, bring down the cost of enforcing rights, and we're going to see that the adoption of digital evidence as well is going to be really powerful, and we'll see more and more businesses using blockchain to support that evidence. So let's have a look at some data. What can foreign plaintiffs expect in litigation? What we have here is an image from our own proprietary database of civil IP litigation in China called Ciela. This is a service that we've been running for more than a decade now, where we take published IP judgments across the IP range, and we analyze those cases to understand trends and benchmarks, and to really bring some clarity to what's going on in the litigation market. We now have over 60,000 IP judgments from across the IP rights from more than 400 IP courts in 250 cities. They cover civil infringement decisions and administrative litigation appeals from the Patent Office and the Trademark Office. And we have also recently ingested over 400,000 decisions from the Patent Office, the PRB, determining the validity of patents, and the Trademark Office, the TRAD, determining the validity of trademarks. That data is just coming online in the system and is going to give another lens to us on what foreigners can expect as they interact not only with the civil IP litigation system, but with the Patent Office and the Trademark Office. So what can we expect? First of all, I'm going to just show you give you an idea of some headline figures. What we're seeing here is the results of all civil trademark infringement cases at first instance from 2006 to 2018. And we've got data showing the figures for all plaintiffs, and then we've split out foreign plaintiffs from domestic plaintiffs. And the striking things I'd like to bring out are, first of all, the high win rates. In cases of clear infringement, the court always supports them. So foreigners have an extraordinary win rate in trademark cases, winning over 90% of the time. That is comparable to domestic plaintiffs as well. But the real significance for foreign plaintiffs is that average compensation figure. I don't know whether you can see my cursor, but here we're seeing an average compensation figure for foreign plaintiffs, which is more than 3 times what it is for domestic plaintiffs. That may be because foreign plaintiffs take litigation more seriously and invest more money in it and seek to develop more evidence to demonstrate the damage that's been suffered. But at least I think it demonstrates that in the vast majority of cases, you can expect a fair outcome from a Chinese court. Although today we're focusing a little bit more around brand, I wanted just to bring up some patent figures as well to demonstrate that this is not unique. Here, again, we're comparing civil invention patent infringement proceedings over a similar period. And we can see, again, two figures I'll pick out. The win rate, foreign plaintiffs winning materially more often than domestic plaintiffs against domestic defendants. Again, that may be because of greater investment from foreign businesses, but it demonstrates what we see as genuinely a level playing field. So to summarize, China is no longer a venue where foreign plaintiffs can say that courts are biased. That, to me, is absolutely clear. The data simply does not support this perspective. And in my view, if I had to summarize, I'd suggest that the system operates a reasonable quality of justice at a reasonable price, and definitely with a fair playing field for foreign plaintiffs. There's a mention there of the coronavirus and the impact. This has obviously led to courts were shut down for some time, has led to a backlog of work, and I'll be coming back to this when I talk about some other predictions for 2020. Now I want to hand over to my colleague Carol, who's going to give herself a short introduction and then take us through some developments in case law, developments in law and practice, and then developments in case law. Carol.
Thank you, Tim. Hello, everybody. Good morning. I'm Carol. I'm a principal of Rouse. I joined Rouse in 2002. I think shortly after China joined the WTO, and also China has its first amendment of the trademark law in 2001. So I'm very lucky to witness the whole development of China's IP protection. And I have been working with Rouse for 18 years. And later I was transferred to Lusheng because we tried to because we are more engaged into the litigation work. And now I'm in charge of our Shanghai office's litigation practice. All right, so I'm going to share with you today about the recent development about the trademark law and some practice. And also I'm going to share with you some case studies that we have helped our clients to deal with. Tim, next slide, please. Yes, I think this part already has been mentioned by Tim. So basically, I would like to maybe cover next slide. The new trademark law, the key changes around the new trademark law, in my opinion, is mainly 2 things. One is the statutory compensation increase, and another thing is how to deal with a bad faith trademark application. About the statutory compensation, as you know, you probably are familiar, in China, there are 3 ways to calculate the compensation. In turn, they are the actual loss of the plaintiff, and then the defendant illegal profits out of the infringement activities. And third one is that if the plaintiff cannot provide the evidence to prove the illegal profits or actual loss, then they have to rely on the statutory compensation. So the maximum amount of the statutory compensation is a very important indicator to show the level of Chinese, the damages that awarded by the Chinese courts. When I joined Rouse in 2002, I remember at the time, the statutory compensation is only 500,000 RMB. But now, after 20 years, it has been increased to 5 million RMB. And so that just gives the plaintiff, especially the foreign brand owner, a very strong confidence to go to the court, because they can not only send out very strong deterrence to the marketplace, but also they will recover their legal costs and can maybe gain some damages out of the civil litigation. So that is about litigation. And then the change is mainly focused on the how to deal with a bad faith trademark trademark squatter. As you may know, in China, the trademark squatter, they try to make profits out of two ways. Number one is they try to sell the trademark to the genuine IP holder. And if they fail to do that, then they will try to disrupt the business of the genuine IP holder by sending out a complaints letter to the distributor of the genuine IP holder. By that way, they will try to threaten them and try to gain some illegal profits out of that. So the trademark squatter for a long time is a big headache for the brand owner. They have to spend lots of money to do the trademark invalidation, trademark opposition, and other administrative things. And in the meanwhile, unfortunately, for some very aggressive infringer, like I mentioned, they try to disrupt the business of the distributor of the genuine IP holders. The IP holders even don't have very good remedy under Chinese law before. They cannot take aggressive action against those infringers by claiming some damages. We used to help one of our clients to seek a damage under unfair competition law to solve the problem. But now, because the amendment of the new trademark law, it has expressly regulated that if those bad faith trademark applicant try to cause trouble to the genuine right holder by sending complaints or filing civil lawsuits, then they will suffer damages. What does it mean? It means in the long term, we can see that those trademark squatter, they will find more and more difficult to get illegal profits out of this whole business. So in the long term, we anticipate that the brand owner maybe don't worry too much about filing defensive trademark filing in China. But that is just in the long term. In the short term, probably they still have to do that. And last but not least is about the dealing of the counterfeiting items. As you probably are aware, for a long time in China, if the authorities see those infringing items, they are going to destruct them. But sometimes they can remove the trademark from the packaging or from the products and then get them into the market again. Now this has been completely prevented. All of the infringing items has to be 100% destroyed. So that just to show you, China has tried to enhance the enforcement ability against those counterfeits. That is about the key changes and the expected impact about the new trademark law. Next one, please, Tim.
Yep, I am trying to advance it. It seems to. Oh, there we go. Okay. Okay, so for this part, I think it's mainly try to summarize the key changes with the judicial environment. As you are probably, if you come to China and if you decide whether you want to go to the court, maybe your lawyer will advise you that the first consideration should be the jurisdiction. Because jurisdiction is very important. Like Tim mentioned, there are so many courts in China. Even though China's Supreme People's Court try to provide a more unified practice for all of the courts, but it will be a long-term plan. In the short plan, we can still see the big difference between different courts. So that's why the plaintiff, when they try to do a case, try to bring a lawsuit, the first thing they have to decide is about what is a jurisdiction. For a long time, Shanghai, Beijing, and Guangzhou
and Hangzhou, where is Alibaba is located. They are the best jurisdictions. But because they are so good, so many increasing number of the plaintiffs try to bring the case in those jurisdictions. As a result, the judge find out they have a big volume of work, so they do not have the capacity to handle all of those big volume of the cases. So the process is noticeably delayed, and also the damage has been decreased in some cases. And we think the judge just trying to send out a message that they discourage the plaintiff always go to those courts. Then for the plaintiff or for the foreign right holders, what do you think you should do? We think probably you can explore other courts. In our experience, we have actively explored other courts of China, and to our nice surprise, we find out as long as you have provided your evidence well enough, just as Tim mentioned, there are many young judges, they have a passion to become a respectful IP professional, so they do have the momentum to learn more from you. So in those cases, we still think the result is not bad. So, but for the cases which is more not black and white, which is not so straightforward, we still suggest you should very well consider your jurisdiction. In terms of damages, already that has been mentioned. Overall, we think the damages has been increased significantly over the last 3 to 4 years. But in terms of the copyright, because the statute damages still remain to be 500,000, just like 18 years ago. So we think maybe it will be improved in the future, but so far still the damage is not that high. In terms of big data and CLR, like Tim mentioned, when we prepare our litigation strategy, we also need to have a thorough understanding of the judgments concerning the other party. We try to understand their arguments, their situation, and so that we can develop a more feasible plan for our clients. They are doing the same thing now. They will also research on our judgments, especially when they know they're going to lose a case and be awarded some damages against the plaintiff. They will surely try to find out the records where it showed the very low damages to our client. So we think it's very important, if you have never done any, if you have never launched any civil litigation in China, you'd be careful to do your first several cases. Try to make a very good records of the damages as well as the affirmation of the infringement. Okay, next slide, Tim, please. Okay. Now we're going to look at several cases. These cases are handled by our firm, and because all of them are publicly available, so we can share some details here today with you. First one is about New Balance. I think probably you are familiar with that brand. This is very typical lookalike case. In this case, this Mr. Zheng, one of the major defendants, he used to work with Nike for a long time, so he got a big knowledge about the shoe industry. He then registered USA New Balance company in US and also filed a trademark application in US for New Boom as well as IV, which looks like an N. He did the same thing in China as well. And also he registered a company which looks like a manufacturer. With those covered, he appeared to be a legitimate big businessman who has trademarks and also have the real business unit. But it turned out that he signed the OEM manufacturer with a Chinese manufacturer. And then in a very short time, he just managed to sign the contract with distributors all over China and successfully set up more than 200 stores, chain stores in China. That brought him huge amount of money and a huge loss of money. And so for the client, it immediately become one of the most aggressive infringers who is really disruptive to our clients' business. So what we are going to do? The challenge is that maybe we can do the administrative enforcement action. But again, as Tim mentioned, there are many local protectionism there. So it's very difficult for us to take action against the manufacturer. Can we do the action against all of those stores? Cost-wise, it's not feasible. And even the distributor is not the ideal target that the AIC official try to deal with. So civil litigation seems to be the only way a way out. And so at that time, the highest statute damages is only 3 million. Can we just claim that amount of money? We decided not to. Tim, next slide, please. Yeah. So we decided that we think we should send a very strong deterrence into the marketplace, and we should cause as much as possible damages to this defendant to deserve their aggressive infringing activities. So we filed a lawsuit against this defendant, claiming the damage of 10 million RMB, which is around 1.4 million USD. And when we filed the complaints, we also, because we know the civil litigation is going to be very long, so we also filed the application for the interim injunction. 2 months after we filed the case, we received the interim injunction. The court fully supported our claims. Sorry, the court fully supported our injunction, and and immediately after that, we also have raided 5 distributors of them because we do have that injunction, and the injunction is quite convincing evidence to convince the authority to do the action. And by doing that, that enforcement actions, we not only send out a strong deterrent to the market, but also we have obtained the illegal profits of every single store. Those also served as very good evidence to show to prove our damages of their illegal illegal profits. So finally, we successfully convinced overwhelming evidence to the judge that no matter by the illegal profits or by actual loss of our infringer, the damages should far beyond that 3 million. And the judge fully supported our claims. Because this case set the record of the highest damages to a foreign brand owner, it has aroused great attention of the whole media. And also, Tim, next slide, please. It has we have tracked the consumers' feedback towards this case as well, and we've noticed that consumer has a very strong confidence about our clients. So that this case, the litigation has achieved multiple impact to our client's business. Okay. Yeah.
Carol, I'm conscious of time as well, and I'm sure we want to leave a little bit of time for questions. So perhaps you could just spend 5 more minutes, and maybe you want to just choose one more of the case studies.
Okay. So I'm going to finish that within 5 minutes. Yeah. For this Timberland case, it's very similar to that one. Next slide, please, Tim. This Timberland case, the challenge again is not about the trademark infringement case, because in this case, as you can see, the other party copied our client's device, which is a clearly straightforward trademark infringement case. But in the meanwhile, they also copied our client's GetUp and the Chinese name. But our client didn't have the trademark right for their Chinese name, and they don't have any design patent for the whole GetUp. So the challenge here is we try to prove the Chinese name is a very unique name under the anti-competition law, and also the GetUp is quite unique under the anti-competition law. And as you can see, so finally we just successfully convinced the judge that the padding, the sole design, the glass eyelet, and the lacelet are all very, very unique design compared with others. So the whole combination of this whole getup is quite unique and should be totally belong to our clients. And finally, the court supported our claims. Next one, Tim. Similar to that Timberland case, for this Mattel case, again, we've noticed that the client don't have 3D trademark, they don't have design patents. The only way they can rely on is the unfair competition, where we can prove that the decoration is very unique. And in this case, the decoration is a water drop design. The best evidence we have provided is that we provided more than 1,500 pictures of different bottles of the spirits, and to show that the water design is really unique and should be supported. And finally, the court just give us a full support. Next one, please, Tim. Actually, all of those three cases are mainly about the litigation and the litigation strategy. For the fourth case, it is not directly to the litigation, but I think the timing is also important, because in this case, you can see this is our client's product, a toy. We have the copyright over that. The defendant 100% copied it, but they didn't file the copyright record for that. Instead, they started our products and then filed the utility model patent for that. So they have the copyright, and they have the utility model, right? And we have the copyright. So both of us seem to be a balance. We realized that we need to have extra efforts or tool to attack them. And we have done a very good analysis about their whole background and noticed that they're in the process of their IPO, initial public offering. According to Chinese law, if you're going to IPO, you cannot be involved into any big civil litigation cases. So we think if we're going to file the lawsuit against them, this will cause big delay for their IPO. And then we write a letter to themselves as well as their lawyers who advise on their IPO. And immediately we just receive their feedback and proposing some settlement with us. And finally, the case ends up that they have agreed to transfer all of their utility model to us, as well as pay us some decent damages. So we think sometimes you have to think out of IP box. Oh, okay, that's for me. Tim?
Wonderful. Thank you very much, Carol. Some fascinating cases there, and I think fascinating to show the flexibility of the Chinese court and really their supporting of what seems to be the right outcome when even though there may not be registered rights in play, the unfair competition law in particular is a flexible law that is powerful. I'm just going to very briefly finish up with a few predictions for 2020 so that we have some time for questions. What's going to be the impact of the coronavirus? I think in short, we think this could result in increased counterfeiting and lookalike activity. I think we're going to see, we're already seeing slower court actions and less enforcement from the authorities, and manufacturers lacking cash, therefore being in survival mode, looking to turn to counterfeiting to try and generate some cash. That is not a positive picture for the first 6 months of the year. What about the US-China trade war? We've now had the end of phase 1, and we do think that this will have a positive outcome, and we will see greater movement in particular around criminal counterfeit cases and enforcement on e-commerce platforms. So what that really means from a court's perspective is that what we see as a year of two halves. We've had a lot of cases delayed from the first half of 2020, will be delayed into the second half of 2020, which means a slowdown in process. I think compensation levels are likely to be low in this part of the year as well, as the courts are conscious of the need to keep the economy moving and keep employment up. But as we turn into the second half of the year, I think we expect to see the impact of the US-China trade war negotiations benefiting all international plaintiffs, and I think we can see compensation levels also increasing significantly as the government cracks down on bad faith activity. That's our run through the perspectives on the Chinese litigation landscape in particular, and a look at some of the recent case studies showing the development and sophistication of the courts. Hand back to you now, Thomas, to moderate some questions.
Thank you, Tim and Carol. Very interesting to see the development, and as I interpret the increased predictability of the Chinese court system. We have received a number of questions, and I think I will direct the first one to you, Tim, and it has to do with the still the criticism against the China system and it asks about the level of corruption, that there is predictability in the court system, but where does the corruption reside in the Chinese society if it's not present in the IP system?
There is. I'm not going to talk more broadly about corruption. There still remains corruption in local government and the granting of licenses and the like, and the typical kind of corruption we've seen in China. There's obviously been a huge campaign from Xi Jinping that's been absolutely the center of his presidency ever since he came into power. And within the court context, it is. I would like to distinguish some protectionism, local protectionism, from corruption. We do still sometimes see local protectionism. I mentioned it in the beginning around, particularly with administrative authorities who are, the local government not only has a role in enforcing rights, it also has a role in ensuring a vibrant economy and employment. And it's this tension which means we do sometimes see local protectionism. But if we talk about corruption and and literally the paying of judges to make wrong decisions, that is something that I personally have never seen. I've seen cases, marginal cases, that you have lost at first instance, maybe against a large local infringer, which you appeal then to a provincial court and succeed. But that to me is not a question of corruption. That's a question of nothing different than you might, for instance, experience in the United States.
Okay, and here I have another interesting question of more trademark legal character. And Carol, maybe you want to respond to that. We have a EU trademark holder who wants to protect their trademark in China, but is aware of a Chinese user of an identical trademark. How should the EU trademark holder proceed?
Thomas, this is only a EU trademark. Hasn't been this trademark registered in China?
I presume it has not been. That the Chinese user of the trademark has not registered it in China, but the European trademark owner is aware of the Chinese user's use in China.
Yes, because IP rights is a jurisdiction rights. So it has to be registered in China if we try to seek damage or remedy under the trademark law. But if this trademark is super famous, we probably can explore other ways, such as unregistered well-known trademark protection in China. So this trademark has been used in China, right? Or not?
No, the European has not used its trademark in China, but the Chinese market actor is using its trademark in China. So can the European trademark owner be in bad faith if they try to register their trademark in China?
They have to take some, they have to take some actions through the trademark administrative procedure way before they can take any civil lawsuits against this infringer. Such as they need to maybe, if this infringer has registered trademark already in China, then the European trademark owner has probably to, file the trademark invalidation against that trademark, and then they can take action. Because
Carol, sorry to interrupt. I think that this Chinese market actor is not an infringer. They are just using an identical trademark in China, but they have not registered it. Can the European trademark owner enter into a bad faith situation by trying to register it in China?
No.
No?
No. As long as they have, I think this case is a little bit difficult to say because this European IP trademark owner hasn't ever been used this trademark in China. But I suppose this trademark should be pretty famous.
We don't know that.
Okay. And I don't think it is very easily to prove this trademark owner, I mean, European trademark owner has any bad faith to register, simply because they try to register this trademark in China. I don't think that is a case.
Mm-hmm. So we invite the person who posed the question to revert to us, to the Rouse office that is the closest, or where the question is a problem. Let's go to the next question. Maybe you want to answer that also, Carol, or maybe Tim. How come the copyright cases are that much higher than the trademark cases in 2019?
Let me take a stab at that first of all. I think there has been a lot of these, the vast majority of copyright cases in particular are domestic against domestic. And I think a lot of these concern the use of imagery or other copyright works, music, etc. online. So a lot relate to the to use online where the administrative procedures may not be sufficient or takedown procedures may not be sufficient. So businesses turning to the courts for that. Also, we have seen something of a problem in China, very aggressive enforcement of fonts, fonts for text, and also of image libraries, where there are businesses filing literally hundreds and thousands of cases against large corporates who they believe have been misusing fonts to which they have rights or image rights in photographs and stock imagery and things. That has been a significant bulk of cases there too.
Okay, time is running up and I promised to end 9:30 sharp, so we will just have one more question. And I think it's a very common question that we receive, and that deals with the cost of litigation and the duration of litigation in a standard IP case. We realize that all cases are different, but can we say something about the cost of litigating the first instance and the duration?
Carol, perhaps do you want to take that?
Okay, sure. Yeah, for the straightforward trademark case, it will range from 10,000 to 5,000, depending 10,000 USD, depending on the sophistication of that case. Mm-hmm. So it is a quite big range, but normally will not exceed 50,000.
10 to 50.
Yes, I'm sorry. Yeah, 10 to 50,000. We don't think that will exceed that.
Yes.
But for unfair competition and copyright, it can be slightly higher. Normally like 60,000 to 80,000, sometimes for very complicated cases. And for the duration of the court hearing, normally it will be ended within 12 to 18 months for the first instance court case. And if sometimes our clients, they have some subsidiary in China, and we will advise they can use a Chinese subsidiary as a plaintiff, which means the case will be a domestic case. And then in that way, the duration can be shortened to 6 months from the case filing.
Thank you, Carol, and thank you, Tim, and thank you, Ole, and thank you all participants of the webinar. Please remember that we have future webinars. Consult our websites where you can sign on to the webinars. In these times, increased learning is encouraged by everybody, so we hope that we can also contribute to society in that way. There are some questions that we have not been able to address due to the lack of time, so I encourage you to contact the Rouse office, preferably the one closest to you or the one in the country where you have the problem. All the participants in this webinar will be ready to answer to your questions. So thank you very much for attending, and have a nice day.
Thank you.
Thank you all.